Thank you, sir. Good evening, everyone. I'm Shreya, student co-convener of Center for Legal Aid Program, NUSRL Ranchi. I'll be your host for this evening. On behalf of CLAP and ProBono India, I welcome the resource person, Professor Dr. Ashok R. Patil, members of the organizing committee, Dr. Kalpesh Kumar L. Gupta, founder of ProBono India, Dr. Kaushik Bagchi and Dr. Shweta Mohan, faculty conveners, CLAP, student coordinators, and all the participants to the short-term course on legal aid and allied laws. For this session, we have with us Professor Dr. Ashok R. Patil. He is currently serving as the Vice Chancellor of NUSRL Ranchi. He joined NLSIU in August 2008. At NLSIU, he is Chair Professor of Consumer Law and Practice, Ministry of Consumer Affairs, Government of India, and Founder Director of the Online Consumer Mediation Center. His academic and research interests include consumer services, online mediation, insurance law, international law, corporate law, food laws, ISO and ISI standards, regulatory authorities, e-learning, and clinical legal education. He holds an NCCC certificate and NSS certificate and is an accredited mediator. He is a member of several boards and institutions such as the International Association of Consumer Law, Consumer International London, UK, and International Academy of Financial Consumers, Seoul, among others. He has received the University Grants Commission's FIP Fellowship, the Asian Law Institute's Fellowship, the Legal Education Innovation Award 2013 by Society of Indian Law Firms, and the Menon Institute of Legal Advocacy and Training by Professor Madhava Menon. He also received the International MacGennett Award in 2014 at Cape Town, South Africa, as a faculty coordinator for the Legal Service Clinic. We welcome you, sir.
Thank you, Shreya. Thanks to Kalpesh also, Kalpesh. And today we are discussing on consumer protection and how consumer protection laws helpful for the poor, downtrodden people of the society. So that is the topic we are discussing. And I'm stressing in this session more on how students can make use of this Consumer Protection Act 2019 and help the society, and also as a student how you can learn practical skills while you were in student life. So object of discussing this particular practical aspect is the law students after 5 years or 3 years you should be fully skilled person. You should be ready to start practice in court. So that is the object. And also our founder director of National NLSIU Bangalore, Professor Madhav Menon, always he stress on one point: you don't call it as a legal institution, legal education, you call it as a justice education. Always he stress on, because this law colleges, law students is there to help the needy people, provide the justice to those people. So in that regard, institution, faculty and students should work hard and help the people. And also the students will get how society works, how laws are applicable, and how drafting should be, how you should approach government departments. These are the skills you are learning while learning. That is the object of this particular session. I'm showing you live examples how students can involve and help the people, especially using this particular Consumer Protection Act, earlier under 86, now under 2019. About the Consumer Protection Act, this is a consumer welfare legislation exclusively to protect the consumers. Consumers are weaker party. Always, consumer is one side, another side is the business, and business is powerful in the financially, muscle wise, or any you take any way, the business is powerful than consumer. Hence the government of India thought of, let us protect the weaker section, that is consumer, against these exploiters, the manufacturers or the service provider. In that regard, first time at the international level, consumer rights are recognized in US. First time John F. Kennedy, then president, introduced these consumer rights in US Congress. Later, at the international level, UN came out with United Nations guidelines on consumer protection in 1985. And later, India should be proud, that we should be proud because India adopted the independent legislation, enacted independent legislation, that is 1986. The rest of the other countries who are member to UN, they amended the existed legislations and they added this consumer protection. But India enacted independent legislation exclusively for consumers. Not only that, independent redressal system also established. So that is the way how the India adopted, taken it very serious about the consumer protection. And even our constitution, even though the fundamental right is given to the business people to do business, but at the same time, it's not a absolute fundamental right. It is this, the reasonable restriction can be imposed. State can put reasonable restrictions in the interest of public. Hence, these welfare legislations enacted to in the public interest. So, among them, the Consumer Protection Act is also one. After 1980, 1986 legislation, a lot of changes happened throughout India. Digital era has come and business started through e-commerce. Compared to the physical transaction, e-commerce increased, and that's why government of India thought of, let us amend the 1986 act. Especially during Congress government time, I'm also associate with the Ministry of Consumer Affairs, Government of India since 2008. 2008 to 2014, we thought of, during Congress government time, we thought of amending the existed 1986 Act. So we even prepared the bill also. But in 2014, the election announced and BJP government came. Then the Honorable late Minister Ram Vilas Paswan took charge of Consumer Ministry as a cabinet minister. Then he is the person who looked into this legislation. Instead of amending each section, let us go with a new legislation uh, and comprehensive legislation. So in that way, the 2015 bill was introduced, Consumer Protection Bill 2015. Then it was introduced in Lok Sabha, Lok Sabha referred it to the Parliamentary Standing Committee. And again, Parliamentary Standing Committee invited all the experts throughout India and took their inputs and submitted a report to Parliament. And again, it was reviewed and prepared the Consumer Protection Bill 2018. When it was introduced in Lok Sabha in 2018, again election announced. Again, bill was lapsed. Ultimately, in 2019, it was the passed in Lok Sabha, Rajya Sabha, and President signed, and 2019 Act enacted. After 1 year, it came into force in 2020. Whatever loopholes were there in 1986 Act, a lot of things improved. New chapters were introduced, and existed 86 provisions. Uh, amended according to the new uh, scenario, new business. So that is the new area which we are touching upon. And now I mean, don't think that only purchasing a goods physical mode, then only we are facing a problem. Not like that. Other things like now new areas in e-commerce, there are new things like presently I'm assisting the Ministry of Consumer Affairs, Government of India on many of the policy matters. First one, the greenwashing means some of the products are sold saying that it's a sustainable development or we are using organic material. Actually they are not, and customers think that if they are using the the organic thing, they are ready to pay more amount, and they want to purchase it. But that particular thing is cheated by some of the companies, unnecessarily misleading the customer and selling the goods. So that is a greenwashing. One meeting was done and another meeting is in this week end. And earlier new other concepts like a dark pattern in e-commerce. Again, the lot of when you want to purchase some particular item, and even if you click one particular thing, it will take to the another website where they want to show, not what customer wants. So that way that particular website taking you without your consent to another website, to another product. So that is called dark pattern. Other aspects, the even though there are two types of e-commerce companies. One is the marketplace e-commerce company like Amazon, Flipkart. Another one is inventory e-commerce, which is having their own website, own products like Geo, like that. So here these Amazon, Flipkart, or any marketplace e-commerce companies, they are allowing the sellers on their platform and selling the goods. And if consumer purchases the goods, if it is not good or if it is a defective, then he wants to file a complaint to the seller, and seller is not responding, or seller is not helping the consumer to settle the matter. Then consumer is, there is no alternative way for him to get the justice. He is also filing a case against the platform Amazon, Flipkart. Here Amazon and Flipkart taking a defense that we are not sellers, we are just a platform, and you cannot file a case against us. That was the argument in majority of the cases, but that was not accepted by the state commission or national commission, saying that consumer is entering on a Amazon platform or Flipkart platform, trusting your platform, not trusting the seller. And he don't know before entering into your platform who is the seller also. So in that regard, you are, means the marketplace e-commerce entity, you are held liable jointly or and severally. If the seller pay the compensation, settle the matter, it's okay. Otherwise, you are also held liable to give justice to the consumer, aggrieved consumer. So in that way, that is called fallback liability principle. Other than that, in majority, you take in different name, misleading advertisements are huge in the social media. And especially under the Consumer Protection Act, there is one particular section, unfair trade practice, wherein whosoever gives a warranty or guarantee and without any substantial support or without any uh, genuinity, then if anybody, any consumer, aggrieved consumer files a case against these misleading advertisement who are making tall claims, then burden of proof is on the one who is making a tall claim, not on the consumer. This is very, very important, because it is not possible for consumer to prove that tall claim is false. That's why the legislators thought of putting burden of proof on the business who are making tall claim. They know that what is the base for that tall claim, and they have to show, they have to prove that this particular tall claim based on this scientific method. If they fail to prove that, then automatically they have to pay compensation to the consumer. So that is very, very important provision in the, under the Consumer Protection Act. Then another new area is fake review. Nowadays, all majority are purchasing online, and majority we are checking stars. Is it a 3 star, 3.5, 4 or 5 stars? It means rating of a product. So if it is a 4 star or 5 star, you are not cross checking, is it a genuine product or is it a different type of product. You are not checking as a consumer. You are blindly purchasing that particular product where 5 stars are there. Nowadays, there are companies doing business. They're asking the goods, I mean, the products companies, here is a package. If you want your product should get a 5 star rating, you have to pay this much amount. We will see that your products will get a 4 star or 5 star. So that is the way there are companies coming up and products in on e-commerce. They are hiring them to increase their rating, which is not genuine. It is nothing but it's called fake review. Again, central government worked on it and 4 5 meetings done. Another thing we should appreciate, Ministry of Consumer Affairs, Government of India, whenever they want to bring new policy matters, they are inviting all the stakeholders, including FICCI, CII, ASCOM, and if it is a e-commerce related, then Amazon, Flipkart, Meta, Google, Facebook, Swiggy, everybody, I mean, invitation goes to all these companies and representatives attend the meeting, and on that basis, they, I mean, ministry takes their response and come out with the policy matter. So this is the way the government of India is working. And another recent thing is the last month one meeting was happened, uh, cross-border dispute settlement through online mediation. Now we have a meeting with the United Nations organ, and we are working how to bring the online mediation to settle cross-border disputes. So that is also happening. So these are the new areas in which students have to work hard, come out with your suggestions, send your suggestions to the ministries, regulatory authorities, so that they can make use of your suggestions and the change the policy to protect the consumers. I'm repeating the those concepts, new areas where you can work. One is greenwashing, dark pattern, fallback liability principle, misleading advertisement in that, burden of proof, fake review, cross-border dispute settlement through online mediation. So this was started now, but in 2015 itself, when I was in National Law School, Bangalore, we launched the Online Consumer Mediation Center in 2015 before Consumer Protection Act 2019 was having the mediation chapter. During that time, we handled disputes between e-consumer and e-commerce companies. And even we invited all e-commerce companies for the meeting. Even Amazon came and interacted with us in National Law School, Bangalore. One day, around 8 people came, discussed, and they were happy with this particular online mediation. But afterwards, they have not come forward to settle the matter through online consumer mediation center. When I asked them why you are hesitating to settle the matter, then they said, our head office said, there is no authenticity once we settle through online mediation. So mediation is not recognized under the Consumer Protection Act. Hence, we cannot come for the settlement. So that is the report I submitted to Ministry of Consumer Affairs with the detailed report, and they considered our report and one independent chapter on mediation under the new Consumer Protection Act 2019 added now. So that is the way how evolution happens, and that is the way law students and law schools can help the state to bring policy changes to protect the weaker sections. So these are the some of the points I wanted to share. Now I will come back how students can help the society, help the needy people by filing a cases. So I'm sharing you some of the live, I mean, cases which are filed by the students, and students themselves the drafted the complaint, drafted the notice, and argued the matter and won the case. So here under Consumer Protection Act, it is different from the regular court. Consumer Protection Commission is different from regular court. Why independent redressal system is established? Why not the consumer cases also jurisdiction given to the civil court? What state thought of? Already we are having regular court, and what are the problems we are facing in regular court? Everybody knows it. That is delay in disposal, complicated procedure, heavy court fee, heavy advocate fees, and the lot of protocols. Consumer, he himself cannot able to file a case and argue his case in civil court because of the complications. So hence legislature thought of, let us come out with independent redressal system exclusively for consumers. So here, very important thing why I am stressing this one, being a student, you can file a complaint before Consumer Commission. You can argue your case or your friend's case. So you here, you will learn the drafting skills, handling the opposite party advocate or client, or how to answer, convince the Consumer Commission members and president. All these things you will learn when you were students. That's why I'm stressing this point. This is the way how you can help the society. This is the way you can, through legal aid clinic, you can help the society. And especially here, what challenges you can face? Even I'm taking first year students, not final year students. First year students also, you are capable to draft a complaint, draft a notice, and file a case and argue the matter. Why? Because here civil procedure code is not applicable. There is no need for you to draft a complaint as per civil procedure code order 7 rule 1. No, CPC is not applicable. Just draft a complaint. Only you have to look into the territorial jurisdiction and pecuniary jurisdiction. Now that is also amended in 2019, and you are comfortably in your place where you are residing, there itself you can file a complaint. And another challenge you may come, sir, we are students, we don't have a pocket money to pay the court fee. Then under this Consumer Protection Act, up to 5 lakh rupees claim, there is no court fee. There is no need for you to pay any court fee. Only thing you should have a, mindset to draft a complaint on white paper, attach one affidavit, and attach the consideration if you purchase a laptop, the receipt of the laptop, and in your complaint, what is the problem you are facing, you have to write, sign it, and submit it. Another very important, it is not like a code. If you look into the Consumer Protection Act 2019, every word used in the Act 86 as well as 2019, intentionally legislature not used those words which are used in the regular code. Example, we are not calling it as a code, Consumer Commission. district consumer commission, state consumer commission, national consumer commission. In short form, consumer commission. We are not use the word consumer court. We are not using calling it as a court. Once we use a court, the public will fear, oh, court means it's lot of restrictions. Then the one who is presiding, giving a decision in the consumer commission, they are not called as a judges. In regular court, they are called as a judges. Here, they are not called as a judges, they are called as a president and members. And dress code is also should not wear as the regular court judges are using. They should wear normal sober dress. And also the consumer commission infrastructure should not look like a regular court. Even the consumer commission president and members should not use high-ended chairs, the same chairs which are used by the clients, consumers who are sitting in that commission. The same type of chairs should they should use. And even that should not be where they are sitting. Height should be more than, it is 3 inches. It is not like a 3 feet. So these are all depicts the consumer should feel comfortable when he enters the consumer commission. He should argue his matter personally. So once his mind is cool, he is comfortable, he can apply his mind and argue his case personally. And another very important thing is, along with the retired judge who is presiding, president of the consumer commission, two members are sitting along with that particular president. Those two members are social workers. In regular court, only one judge is sitting and deciding the matter. But in consumer commission, along with the retired judge, two other members are sitting and deciding the matters. Intention behind it is those are the social workers, those have worked for the society. They know the problems of the grassroots level and needy people, unfair trade practice. So all those things they know, and they help the president to give justice by understanding the reality of the consumer. And also, if any consumer comes and he is unable to uh, perform, then there should be help desk to help that particular person. And another thing, if a opposite party business appointed advocate and this side law student is there or a consumer is there, there is an imbalance of things also. He is a well-read advocate. Even then, the business appoints an advocate against a law student or against a consumer. Always consumer commission tries to balance that. So that's why the Consumer Protection Act says whatever the advocate wants to say, first he has to submit in written form so that consumer can read and understand and prepare his case. Even final argument, if advocate wants to, if the final argument is fixed, 2 days prior to the final argument, he has to submit written argument to the opposite party consumer so that consumer can read and understand and prepare his defense. So in lot of ways, they have provided, accommodated to make consumer comfortable. So that's why it is a very simple legislation, understandable, and law student. See, when it is designed for a layman, you are a law student better than layman. You can deliver excellently by representing your case, your friend's case, or on behalf of the NGO. Through NGO also you can represent. So these are the opportunities available to you. Make use of it seriously. Now I will show you whatever I have said. And another thing, in why we are discussing in legal aid, everybody is consumer. From birth to death, everybody is consumer. And everybody is purchasing goods or hiring the service one or the other way. Hence, it is applicable to everyone in the society. There is no exception. Maybe seller, he is a consumer for, he is a seller for one product, but rest of the products, he is also consumer. So that's why this legislation is very, uh, I mean, powerful, or it reaches to everybody in the society. Always, that's why always Professor Madhav Menon appreciated the Consumer Protection Act, and always every year, every 6 months, he used to organize continuous legal education on consumer protection. Throughout India, Professor Madhav Menon conducted on this topic. I was there assisting him on for this particular continuous legal education on the consumer welfare legislations. So that's why you have to take it very serious. Actually, the strength and importance of Consumer Protection Act is not yet reached even in majority of the law schools or law universities. It is taught as a part of the law taught in National Law School Bangalore. We taught one independent subject. There will be a taught one, taught two. Taught one exclusively the taught principles, taught two exclusively consumer welfare legislations. In that, we taught Consumer Protection Act, Legal Metrology Act, Bureau of Indian Standards Act, then regulatory authorities like the RBI, IRDAI, Insurance Regulatory Development Authority. So like that, many legislations we discussed, which are very, very near to the public. And everybody takes insurance. Everybody is having a bank account. So it touches everybody. So that's why this is very, very important subject. Earlier, name was not there, at least BCI included. Now, Consumer Protection Act, the Motor Vehicle Act, and the Law of Tort. Again, this particular Motor Vehicle Act is the tort principles angle only. The Motor Vehicle Act has to be taught, not a complete legislation. So in that regard, a lot of changes is needed. So it will change in future. So let us come back to the topic. Now I am sharing you how students can involve in legal aid and help the society and help the state to change the policy to protect the consumer. Let us look into this one. Just a minute. File screen. One minute. Give me. Uh, okay, I got it. So I'm showing you some of the cases how the students can involve. Is it visible?
Yes, sir.
Yeah.
Yes, sir.
So I'm showing you some of the slides how the NLSI students involved in consumer protection. So just I'm showing you High Court notice. There was a public interest litigation filed by the students. And when in Karnataka state, a lot of every district should have a district commission, and the district commission was not having I mean, state has not appointed the members and presidents, and the students did a empirical research through RTI using Right to Information Act. They collected the data of every district, and around 60% of the district commissions vacancies were there. They were not appointed. Then they prepared a report and submitted to me, and I took that particular report and met the secretary of Ministry of Consumer Affairs, Government of Karnataka, and requested, see, consumers are everywhere and they are facing a problem, and kindly appoint these 60% of the vacancies, presidents and members at the earliest. 1 hour we discussed, and at the end, the officer said, well, I have other important work to do. I don't have time to do these things. Then I came out again with the students, discussed. Then we decided to file a PIL, public interest litigation. So again, see here, to prepare a report, empirical research, they, by doing that, while doing that, they understood what is RTI Act, how to file a RTI, how to get the information, how to compile, how to prepare a report, and now after that, how to draft a PIL. Again, they may not, the PIL means before the High Court, and they took seniors' help, drafted the PIL, and again went to the High Court. There also the procedure, where to file it, stitching, even the beginning of the advocate profession, how to file it, how to compile it, how to stitch it, and where to pay the court fee. So all those things they learned while doing this exercise. And ultimately, the PIL is filed, notices are issued to the Chief Secretary, Government of Karnataka, and State Commission President, and the Secretary, Minister of Consumer Affairs. And in second hearing, and another thing you keep it in mind, wherever students approaches High Court or Supreme Court or any court, always there is a positive appreciation from the court. Encourages, the court encourages you to, even if you have done something wrong, they will tell you this is wrong, you improve. They will tell you read and come and argue. So always smooth corners towards the students, because they also knows that you are not an advocate, you are helping the, trying to help the society. So always they will help you. Even sometimes the hearing was scheduled on working day, means the Monday or Tuesday, like that. The students they requested, we have a class on up to Friday, but for Saturday we are free. You can fix the our case on Saturday afternoon, and they are accommodating. They also know that you are a student, and students' classes mandatorily you have to attend, and hence they are very cooperative, accommodative to the students. They fixed always the hearing of your case or student's case on Saturday afternoon. So that is the way they help. In this case also it has done, and in second hearing itself notices are issued to them, and they appeared, and in second hearing itself, Chief Justice of Karnataka High Court directed appoint all these people within 6 months. One who said no to me, the same person appointed all these the members president. And also during that time, 2 new districts were established, but no district commission was established. Those 2 things are also referred, mentioned that, and within 6 months everything is on track. So this shows power of students. So here you help the society, you learned how to draft the notice, complaint, or PIL, approaching the court, paying the court fee, filing it, all these things you learned during your student life. That is very, very important. I will show you some of the other slides. See, during that time, our report clearly mentioned how many cases are pending. All those things we have shared to the media also. Media took it very serious, and always media also helps the students. Only important thing you should keep it in mind, your research should be authenticated, your facts should be authenticated, your statistics should be authenticated, your everything should be as on that date updated. Then nobody stops you. Always everybody helps you and encourages you to provide the justice. Then see, this is a case, consumer fora, PIL filed against state government, food department, Karnataka State Consumer Dispute Redressal Commission. So the even newspaper referred this particular thing and clearly mentioned that what is the problem and who have filed it, all those things are mentioned here. This Basavanagowda Patil petitioner is with 5 members are the NLSIU students. Then the same in other newspaper also they mentioned. Court notice to Karnataka on vacant post in Consumer Dispute Redressal Commission, fill post in consumer forums, High Court to government, many vacancies in consumer forums. So these are the things referred, file the cases, all those things. Law student fight false advertisement. This is another set of cases which are filed by the law students on misleading advertisements. So all these cosmetic companies always here, all multinational companies taken for granted. Your in Indian consumers are not bothered about misleading advertisement because nobody files a case even though they know that it's a false. These types of Indian consumer attitude makes multinational companies to continue cheating, misleading in India. I have seen some of the MNCs advertising same product in developed countries. Whatever truth is there, as per that they advertise. But in India, they do it same product in differently because here laws are not that much strict, and aggrieved consumer are also not approaching consumer commission. One of the national survey done by Cuts International in 2012, it shows only 0.3% of the aggrieved consumers are approaching consumer commission. 0.3. And some percent, 1%, they are approaching the sector ombudsman, 1% approaching to the seller. And ultimately, surprising is around 94% of the consumers are not approaching anywhere. They know that their consumer rights is violated. They know that injustice has happened. Then also they are not approaching. That is the Indian consumer attitude. That is encashing by these multinational companies. So in that way, what I did, I took students to the mall and they purchased before that they did some research on cosmetics and what advertisement given in India and outside, what is that content of the cosmetics, and all those things they did it, and they selected one particular cosmetic. We went to file a consumer complaint. One must be consideration should be paid. That's why I took them in a bus to the mall. They purchased the cosmetics. We came back, receipt, they kept it with themselves, and then they applied on themselves as per the directions of these the cosmetic companies. And after we have a trimester there, so 1 month they applied, all those claims, tall claims were false. Then they sent a legal notice. They themselves drafted the legal notice. They sent to all these multinational companies, and some of them replied, I mean, let us close it. We will give you gift hamper. Or some of them not replied. So like that, it has happened. Ultimately, students students asked 2 3 questions in the legal notice. One, what is the authenticity of your toll claim? Second, which government department recognize your toll claim? Third, if you made any survey, what is the sample size? Who is the funder of your that particular survey? Majority or nil, nobody responded those 3 questions. And ultimately, students drafted the complaint. Again, I took them to the Consumer Commission, and I have not told anything. You have to learn in a commission, Consumer Commission. They went to met the consumer concerned clerk, how to file, where to file, the payment of the fees, where to pay, all those things they themselves learned, and ultimately they filed the case. So in one of the case, uh, I mean, majority of these are all multinational companies. They appointed the senior advocates one side, and another side the students arguing the matter. So this is the way how students can involve and help the society. In one of the case, student argued the matter, won the case, and immediately the senior advocate filed the appeal and took a stay order. Then that also the student won. So those are the success stories which we can see. See, law student fight false advertisement. Another case, students filed against the Pepsi. So this case again filed by the law student. During that time, it was a 2011 case. Uh, the malls, you can see the all cold drinks are sold for a higher rate, and outside lower rate, and price is a huge difference. And the students file it as an unfair trade practice. There is no special services are provided in the mall. Even then they are charging more. Then they filed a case before the Consumer Commission. And interestingly, in this case, district commission members and president, to encourage the students, they themselves visited that mall in Bangalore, very big mall, Mantri Mall. So literally they visited that Mantri Mall and checked what type of facilities they are giving. They wrote in their judgment that nothing is not a special facilities are given, and it is considered as unfair trade practice, and judgment is delivered. Again, immediately the Pepsi hired senior advocate and filed a appeal before the Karnataka State Commission, took a stay order. They managed for 10 years. See, again, lot of problems are also there. Managed for 10 years. Then at the last 2 years back, again, the appeal was dismissed of the Pepsi. So that is the story. All these judgments are available. Uh, I can share with you. So these are the some of the consumers unaware of their rights. So these are the some of the things. Then another, I'm now showing you judgments. So this is a Pepsi case judgment given in first day of April 2011 before district commission. And now the Aditya Banawar, all these students who were in the hostel, now they are law firm partners throughout India and abroad. So Aditya Banawar, now he is in US, he's a partner to one of the big law firm in US. Abhimanyu Company, Ubre, Lakshmi Nair, Ashwini, Oblesh. So versus the palette, that is the shop in Mantri Square. So Pepsi, a Maharashtra one manufacturing company, and Bangalore. So the cases are filed and President ordered, judgment is given, and clearly, see what we have attached. We attached bill. Students attached bill. There is no need for you to prove uh, CPC here. Only thing you have to prove that particular thing. See here, complaint is allowed in part. The opposite parties are directed to stop printing different MRPs to the same quality, quantity, water bottles, Pepsi cans, or bottles, Nimbus bottles of the same quantity, and print only one MRP for all the things equal quantities. Opposite parties are also directed to pay compensation of rupees 5,000 to the complainants within 30 days from the date of this order. Opposite parties are further directed to pay 2,000 to the complainants towards the cost of this litigation within 30 days. So this is the way they got that particular judgment. So this is a Pepsi case. Then they file a appeal before the state commission, and they managed date of disposal 7/2/2022. So systematically, the if you don't have a merit in a case, best way is drag the case. But ultimately, it was decided. Same these people filed appeal. PepsiCo India Holding Company. Then against the same students, Aditya Banawar, Abhimanyu Company. So same thing, and ultimately, in view of the above circumstances, we do not find any error, omission in the order passed by the district forum, and there is no scope to interfere in the impugned order passed by the forum below, and the same is dismissed with cost of 10,000 to be payable to the respondents herein. So this is power of the students. See, here they learnt as well as they uh, help the society. And another thing I told you, the student filed a PIL, and see, this is a case. Uh, they filed it, then they went for appeal in the High Court itself. Basavanagoda Patil, he's a student. Abhilasha Mandal, the hostel name, where room number, everything is here. Resident of 309 Nilgiris National Law School. Atula Krishnamurthy. So all these Tenjin, so all these people filed it. This is a PIL, and ultimately judgment. They looked into all those things and directed state government. We direct the state government to establish the constitute the district commission fora in newly created district in the state of Chikaballapur, Ramnagar, and Yadgiri. Then State Commission is directed to issue fresh notification for filling up all vacancies, if any, in the post of members of State Commission, similarly District Commission. So all these things directed. State government shall make appointments to the post of members of the State Commission, President and members of the District Commission, District Fora on the basis of recommendation of Selection Committee. So this is the way through PIL. It is public interest litigation, which I'm sharing with you in the High Court of Karnataka, Bangalore. This is the writ petition filed and won the case. Is here the original case, then appealed. Then I'm sharing you another juvenile justice also. One PIL is filed. I was heading Center for Child and Law. During that time, this case was filed in 2012. Again, students won this particular case in implementation of JJ Act in state, Karnataka state. in this, it's a division bench. Justice B.V. Nagaratna, who is now just judge in Supreme Court, who will be the first lady, Chief Justice of India. So this is another case where students are involved. Then other aspects which I want to share with you, how you can involve. And also nowadays you can see Upendra Bakshi's articles are coming up on the consumer protection thing. So here I'm referring you, this is the article written by Upendra Bakshi, Pro-Verbal Law Delays. Here he talk about the object of the Consumer Protection Act and is it achieving. So some state governments are not appointing the members president on time. That's why a lot of consumer cases are pending. And as per the Consumer Protection Act, the cases has to be disposed of within 3 months from the date of notice served to the opposite party. In case of lab test, 5 months from the date of notice served to the opposite party. But things are not happening in that way. That's why under the new act, we brought the mediation chapter. If the commission, if the state government is not appointing on time, then cases are pending, then at least cases can be settled through mediation. That is the object behind mediation under Consumer Protection Act. If you look into this particular the article, he has referred throughout the article about the cases. Here Pepsi case he has referred, the case which students filed, even the picture, Nimbus, Pepsi, Aquan, all these things are mentioned, and he has mentioned the case also in his article. And he has mentioned that several features make this case remarkable. The first is that the district commission upheld the complaint made in 2011 by 5 law students, Aditya Banawar, Abhimanyu Kampani, pursuing LLB at NLSIU, and ordered 5,000 rupees compensation. And even for academician, always recognition means the great luminaries at the international level, like Upendra Bakshi, if he recognizes the any faculty's work, that is the great award or achievement. So he has referred my work also. I greatly appreciate Professor Ashoka Patil and NLSIU brought this litigation outcome to my notice, but his contribution extends more fundamentally in encouraging classes to generally learn the law by putting claims of consumer justice to work, and also pursuing in the wider sphere of reforms of a government rationally through working with legislative and other public fora. So this is the way we can work and we can help. So this is one thing. And lastly, again, nowadays students always they are busy, they don't have time, their interest is different. Even whatever you have a interest in that way. One of the trimester I took unfair trade practice. So that is the seminar course I did it, and I kept some marks in the course evaluation. You have to prepare a reel. You always enjoy seeing the reels and preparing the reels. So here I'm showing you some of the reels which prepared by the students for your thing.
हेलो सर। हेलो। तो आपको कौन सी कार पसंद आई हमारे यहाँ? मुझे ये ब्लू कलर की बेलेनो पसंद आई है। इसका फाइनल प्राइस क्या है? तो सर इसका फाइनल प्राइस 9 लाख है हमारे यहाँ। क्या ये आपका फाइनल प्राइस है? एनी डिस्काउंट? तो सर हम और कोई डिस्काउंट नहीं दे सकते, यही हमारा बेस्ट प्राइस है। आप कहीं भी कोई भी मारुति का डीलरशिप में पता कर लीजिए, यही आपको ये सेम प्राइस पे मिलेगा।
क्या कार खरीदना आपका भी एक सपना है? कहीं एक सपना ही ना रह जाए। 2014 के बाद से मारुति सुजुकी और हुंडई जैसी कंपनियां ने एक नई डिस्काउंट कंट्रोल पॉलिसी लागू की है, जिसके तहत वो डीलर्स को मैक्सिमम 5,000 रुपीज डिस्काउंट तक देने की अनुमति देते हैं। अगर डीलर्स ऐसा नहीं करते हैं तो उन पे भारी भरकम जुर्माना और साथ ही उनकी सप्लाई रोक देने की धमकी दी जाती है।
मैंने आपके यहाँ से स्विफ्ट डिजायर खरीदा है, इसके साथ कौन कौन सी एक्सेसरी फ्री मिल रही है मुझे? सर, हमारी कंपनी की पॉलिसी है जिसके तहत हम बस 2,000 के ही एक्सेसरीज आपको फ्री में दे सकते हैं।
लग रहा है कि ये पॉलिसी सिर्फ कार प्राइस तक सीमित है, तो आप गलत हैं। कंपनी मारुति सुजुकी और हुंडई अब चाहते हैं कि आप उनके एक्सेसरी जैसे कि सीट कवर और कार कवर तक के लिए पे करें।
मैं आपके सामने लेके आ रही हूँ मेरा फेवरेट प्रोडक्ट गार्नियर विटामिन सी से। इस प्रोडक्ट ने मेरे को 3 डेज में ब्राइट एंड स्पॉटलेस कर दिया है।
ये तो वही मिलियन फॉलोवर्स वाली यूट्यूबर है। तुम्हारा नाम मोस्ट यूजलेस। हाँ जी, और आज ये क्या कर रही हो? ये क्या है? प्रोडक्ट क्या है बताओ। अच्छा, ये क्या प्रोडक्ट है?
इट्स अ पेड प्रमोशन बाय गवर्नमेंट।
अच्छा, क्या करता है ये?
Actually, you should try it. 3 days में it gives you bright and spotless.
अच्छा, स्पॉटलेस। तुमरे तो स्पॉट्स गए नहीं। तुम क्या प्रमोशन कर रही हो? झूठ बता रही हो जनता को। बता रही हो तुम।
You मैंने without इसकी प्रमोशन।
Hi there, I've come in today to buy myself a new smartphone. Money is no object, however, I'm looking for something that's incredibly long lasting and super durable. Can you assist me and help me pick up the right model? Of course, sir, we can help you. I actually have the perfect model just in mind. Have you considered the new iPhone 6 series? Incredibly sleek, incredibly thin, great hand feel. This will certainly last you a lifetime. You should strongly consider this. Well, that's an interesting choice. This certainly does look like a good quality phone. Do you think this will last me a while? Let's say, at least 5 to 7 years? Because if I make the investment once, I don't want to have a recurring expenditure on my smartphone. Certainly, sir. iPhones are the most durable phones we sell, and I definitely think it'll last you for as long as you need it. You should go ahead and consider purchasing it. Sold! You know what? I will go ahead and take an iPhone. Thank you so much. That's interesting. I just got a notification for the new iOS update. Let me go ahead and update my phone. Oh no, my phone. It's stopped working. It's barely switching on and the performance seems to have rapidly diminished. I wonder why. I think this is because I went ahead and updated the iOS to the latest model. This is definitely an unfair trade practice. Apple was actually fined 10 million euros by an administrative court in Lazio for this exact practice. It was found that Apple actively went ahead and encouraged consumers to install an iOS update onto their iPhone 6s without informing them that this update would lead to their smartphones slowing down. Under the CPA 2019, specifically Section 247(1)(a, if a seller falsely represents that their goods are of a particular standard, quality, or grade, that would constitute an unfair trade practice. What Apple did by failing to inform its consumers about the effects of the iOS update clearly constitutes an unfair trade practice, and consumers of the iPhone should have received a fair warning for the same.
साहब भाई, मेरा एक हेयर ऑर्डर करना ऑनलाइन। कहाँ से? फ्लिपकार्ट से कर दो। फ्लिपकार्ट से? फ्लिपकार्ट का आपको मेरे पास हेयर ड्रायर ना? हाँ, हेयर ड्रायर। और बहुत सारे ऑप्शन से पहले मैं कर दूँ? हाँ, कर दो। जल्दी आ जाना। हाँ, ठीक है। हाँ, हो गया 2 दिन में आ जाए। चलो
अरे भाई साहब, ये तूने क्या ऑफ ब्रांड फ्लिपकार्ट स्मार्ट ऑर्डर कर दिया हेयर ड्रायर? नाइस में रेगुलेटर है, नाइस में कोल्ड एयर का ऑप्शन है।
भाई पता नहीं जो उससे ऊपर था, वही पूछ के कर दिया।
भाई जरा आप दिखाना यार, क्या तूने ऑर्डर किया? सस्ता हो तो चलो समझ भी आए। या ये देखो फिलिप्स का नोवा का सेम प्राइस पे मिल रहा है, रेटिंग भी ज्यादा है उनकी, बिक्री भी ज्यादा है, रेटिंग हाई भी है।
हम लोग इसे देख ही नहीं पाए, ऊपर ही वाला आके हम लोग ने पॉपअप कर दिया और हम लोग ने कर दिया ऑर्डर।
What we just saw here was an instance of search bias, where the platform in question would manipulate the search result to favor sellers of its own choice. And in this case, the seller happened to be directly linked with the platform. What this directly comes in conflict with is Section 2, subsection 47 of the Consumer Protection Act and Section 4 of the e-commerce rule. So the next time you open your Flipkart or Amazon to buy something, be cautious about the seller.
Last one.
Education is a very profitable business. A lot of people invest their money to run private universities in order to make money. This gives rise to the problem of fake universities. There are universities which are not authorized by the UGC to run as universities. However, there are a lot of universities which are doing so. So that amounts to unfair trade practice. There is a list issued by the UGC every year listing out the fake universities. Please ensure that you go through those universities and never apply to those universities. If you come in contact with any other university which you believe is fake, or you have a reason to believe it is fake, or you get the information that they do not have the requisite requirements to run the universities, please contact us so that we can resolve this problem.
Okay. Right. So this is many things are there now. Time is a constraint. I'm stopping here. With this, I conclude. This is the way all the students make use of this simple legislation, Consumer Protection Act, to change the society, to help the needy people, and to help the state, even regulatory authority, to make a changes, because there are good officers in the government. They want to help the society. They want to change the policy. Only we have to help them by doing a research, providing the precedents and factual things, so that on that basis they can take quick decisions and implement the policy changes. With this, I conclude. Thank you very much.
Thank you so much, sir, for an informative session on consumer practice. We can have a short question and answer session. Participants are requested to please put their question in the chat box itself. So we have a question here. Can we file a complaint if we purchase goods from a roadside food vendor?
See, under the Consumer Protection Act, it clearly mentioned who is a consumer. And the consumer definition says whoever purchases goods for consideration, and one who paid the amount, that person is also consumer. On behalf of whom he has paid, that person is also consumer. Once you prove that particular thing, you paid the consideration and you purchase the goods, whosoever may be the opposite party, it is immaterial. You have a right, you are a consumer, and you have a right to file a complaint. So no doubt about it.
If one faces food related issues, what to do and where to go?
See, food related issues under, under Consumer Protection Act, what is food, what is adulteration, that is not defined. What the Consumer Protection Act says, defective product means if it is not as per the standard existed as on that date. So for example, food is a product, goods. What is the standard of a food? That is given under the Food Safety and Standard Act. And under Food Safety and Standard Act, Food Safety and Standard Act Authority of India, FSSAI. So it has come out with the standards, how much chemical can be added, how much color can be added, all those things. So if that is violated, then it is defect under Consumer Protection Act. That's the first point. Where to approach? So under food safety and there are two ways. One, you can send it to the lab test and take a video and approach the concerned seller immediately, send an email. You have to create the proof that you are a genuine consumer. How much quickly you can do, that much weightage for your complaint when you file a consumer complaint to the commission. Another alternative way is under Food Safety and Standard Act. So under that act, every state is having a Ministry of Food, and each district is having a food inspector. And in corporation area, in municipality area, food inspectors are there. So it is their duty to look into that. So you can give a complaint to those people and they have to take care of that particular complaint. But always I have observed in all the majority of the states, always there is a grievance from these welfare legislation departments. We are having a less number of staff. Our staffs are not trained. So these common answers I have got. So that's why always you keep it in mind, even though if you have given a complaint, if they are quickly not responding, where to keep that food. So that is a challenge for the consumer. So in that regard, as much as possible, take a photo, video, send it to the seller, and then send it to the on the same day to the food inspector. If you visit website nowadays, all the concerned officers emails are available. So let us finish that one immediately. Later we can follow up those cases, but immediate creating a proof is very, very important. So that's why always you try, send an email, make a video, photo, all those things, and later you can fight before the Consumer Commission or before the food department. So that is both options are available to you.
So, do you suggest that drafting of consumer complaint should be there in first year itself?
Yes, drafting of complaint should be first year, but anyway, law of taught in first year itself in majority of the universities, and there itself, because first year students, they are not expert in all the law subjects. Hence, law of torts should taught in first year, and the drafting of the complaint is not involved Civil Procedure Code Order 7 Rule 1. So like that, there is no application. Only thing is you should look into the territorial jurisdiction and pecuniary jurisdiction, and what is the grievance you have. You have to write chronological order and what is paid the consideration, what is the grievance, and those things has to be mentioned and submit. So yes, it's a simple one. That's why this subject should be taught in first year only.
We have another question from Dr. Pranay. Sir, what is the time required for decision by each commission, and can there be ex parte decisions?
Yes, as I have mentioned, 3 months from the date of notice served to the opposite party. If I file a complaint today, and commission will send the notice to the opposite party. Once the opposite party receives the complaint from the notice, from that date, 3 months, case has to be disposed of. If lab test is needed, then 5 months. Always I come across, because I'm training all the Consumer Commission judges throughout India, in each state as well as National Judicial Academy. I know their problems also. One of the problem is serving of notice itself takes more time. That's why in new Consumer Protection Act, we have added electronic mode of serving of notice. So while consumer filing the complaint, Consumer Commission members has to stress upon the consumer, you have to, along with the address of the opposite party, business, company, you should write even the email address. If it is a company, company should have a registered office, company should have a registered address, email. So you take that email and write it in the complaint, and Consumer Commission will send email also. And they cannot take a defense that I have not checked my email. No, you don't have a defense. When you have given an email address with the registered office, it is your duty to check every day which emails you are receiving. Hence, that is not a defense to escape. So nowadays, even National Commission, District Commission, State Commissions are issuing notices through email, and a lot of cases are disposed of within the timeline. And ex party, yes, once the notice is served to the opposite party, if he is not coming forward to represent its case, then yes, ex party order can be passed by the commission.
We have another question from Mr. Shubham Srivastav. If the company refund the money for defective product, then can one claim compensation also?
Yes, it is depending on your prayer, how you file a complaint and what is your prayer. In that prayer, replacement of the product or repair of the product. Additionally, you can add on different grounds, mental agony, how much you spent for traveling or approaching the repair person. So all those things together, you can ask compensation. And again, another very important aspect you should keep it in mind, even Consumer Commission is having a power, even though the consumer has a right to claim some amount under some ground, but he has not claimed that. Even then, Consumer Commission has a power to compensate that person, even though it is not mentioned in the prayer. That is one. Second one, if it is an unfair trade practice, it is affecting consumer as a class to the whole society. But some people have approached Consumer Commission. For example, if one particular branded the mobile is sold, and one person approached Consumer Commission, and Consumer Commission found that a particular branded badge has a defective battery. Then under the Consumer Protection Act, Consumer Commission can collect information, what is the turnover of those products, how many products are sold of that particular batch which is having a defective battery, should be recalled, and also the total number of turnover. On that basis, compensation can be ordered. Compensation can be ordered, but that one person will get his own share. Rest of the compensation goes to consumer welfare fund of that state, and that fund can be used for the consumer awareness programs in that state. So that is the way Consumer Commission has a power to do.
We can take up the last question for the day. Pharmacists nowadays do not return the unused medicines, claiming the company will not return or exchange if some tablets or capsules used from the strip. What can be done?
See, pharmaceutical nowadays do not return unused medicines, claiming the company. You are talking about consumer purchased it, but if it is unused, he wants to return it. That is the meaning. If that is the meaning, see, yes, okay. So when you purchase the medicine, if it is wrongly given, what you asked, prescription is there, but he has wrongly given, yes, it is mandatory for him to replace, take back and give proper one. Otherwise, what you asked, you got it. Then it depends on the shop also. Sometimes they may not, because what you asked I have given, and now because tablets are exhausted, I purchased from the company huge number. If I take back again, it will be loss for me. So in that circumstances, it is a very difficult to take back. But in hospitals, if a patient is admitted and you have purchased medicines at the time of discharge, if you have a medicines, they will take back. So they will take back. And some of the medical shops, if you know personally, if that particular packet is not damaged as it is there, majority of the medical shops, they replace it. Sometimes they will put it in the receipt itself, replacement, or we will not take back. So on that basis, it depending on the each case, it has to be decided.
Thank you so much, sir, for addressing all the queries. Now I welcome Dr. Shweta Mohan, faculty co-convener of CLAP, to deliver the vote of thanks.
Hello, am I audible, Shreya?
Yes, ma'am, you are audible.
Okay. Students and the organizing committee, I would like to thank Professor Dr. Ashok R. Patil for sparing his valuable time and being with us today. Sir, it was indeed our privilege to be part of such an informative session. As Sir has highlighted the topic of consumer protection, it is undoubtedly very significant in today's age as well as our consumers. It is important for us to know our rights. As a law student, there are many ways through which we can help. Yes, and Sir has very nicely described the practical aspect. He has also shown us some of the videos that was very informative. We can be a part of redressal mechanism, make use of our tools such as RTI, and also provide legal aid wherever necessary. So thank you, sir, for highlighting all the important aspects for us. It was truly a great learning opportunity. Thank you once again, sir.
Thank you so much, ma'am. Thank you so
very
much,
sir.
ma'am. With this, we conclude this session. Until we meet again tomorrow, thank you.
Thank you.
Thank you very much. Thank you very much, sir. Thank you very much.
Thank you.
Thank you.
Thank you, sir.